Okay, hi everybody, welcome. Thank you for joining us today. I am Michelle Weiss. I'm a tax controversy attorney at Holtz, Lavin & Drapkin, and I am the chair of the tax section. So thank you for joining our program. And I also want to thank the Trust and Estates section for co-sponsoring. Today, we're going to have a program regarding the new RMD rules. The course will cover the new rules for required minimum distributions from qualified retirement plans and IRAs that have been enacted in recent years. The course discusses changes that may be required to existing trusts and planning opportunities that may be available under the new rules. Our presenter today is Robert Lowe. He's a partner in the Los Angeles office of Mitchell Silberberg Knupp, where he heads the employee benefits and executive compensation practice. His practice includes all areas of employee benefits and executive compensation, including qualified and non-qualified retirement plans, multi-employer pension and health plans, benefit plan issues, benefit plan investments, and many other areas in that area. He's been practicing for many years and has lots of experience. He received his law degree from the University of California, Berkeley, Boalt Hall, and his undergraduate degree from State University of New York at Binghamton. Bob has a pretty full program today. So if you have questions, put them in the Q&A, and Bob will try to handle them at the end of the program. He's going to leave about 10 minutes at the end for questions and answers. And so Bob, with that, take us away. Thank you.
All right. Good afternoon, everybody. I am now going to share my screen. So hang on a second. Let's make sure I'm doing this right. So you guys should now be seeing the PowerPoint. If there's a problem, let me know. So as Michelle indicated, I'm an employee benefits lawyer here in Century City. I specialize in all types of benefits, retirement plans, health plans. Today, we're going to be talking basically about a retirement plan topic, the RMD rules applicable to retirement plans and IRAs, and kind of how the rules have changed in recent years. Okay, so why are we even talking about this? What are RMDs? And I'm going to use that term a lot, so that stands for required minimum distributions. Why are we even talking about this? What does it matter? Why do these rules exist in the first place? So the underlying concept is that these plans are retirement plans. You shouldn't be able to leave your money in indefinitely. That would mean not serving retirement plan purposes. That might serve some other purposes. The Internal Revenue Code for many years has had rules that require that at some point you got to start taking this money out, even though you spend a lot of time and effort getting into a qualified plan. There's also tax revenue considerations. You got deductions for putting this money in. Now the IRS wants its tax when the money comes out. So the money can't stay in indefinitely. And for many years, these rules were unchanged. For 20 or more years, we had the same rules. Not very much happened. And people, I think, were largely familiar with them. And a lot of people who had significant balances in their retirement plans based a lot of retirement and estate planning around these rules. And then in the last few years, several things happened that changed these rules. First of all, and some of these changes you might regard as good news, and some of these changes you might regard as bad news. So the good news is, first of all, that there were some IRS regulations that were issued in final form in November 2020 that actually changed the tables that are used for requiring required minimum distributions. The IRS said, well, life expectancies are getting longer, and we've had these tables in effect for 20 or more years, so maybe we should change the tables, and they did. And so for 2022 RMDs, we've had some new tables in effect. In 2019, in December 2019, Congress passed the Secure Act, which changed the RMD rules in several ways. Even though the Secure Act has been with us now for over 2 years, there is as yet no guidance issued, no regulations with respect to the RMD rules under the Secure Act. The IRS has issued a bunch of other guidance about other provisions of the Secure Act, but no guidance yet on these RMD rules relating the rising under the Secure Act. There have been statements by the IRS that their rules are coming any minute now. They hadn't been published as of earlier today. So who knows, maybe later today or sometime next week, we'll see some new rules. But I think in the near future, we will see some guidance about some issues under the Secure Act. Obviously, this has taken the IRS some time. It indicates to me they may be struggling with some of these issues. And then there was also the CARES Act, which is largely pandemic relief. Most of the issues about the CARES Act are behind us, but there are a couple of issues that are still have some relevance that I'll talk about at the end of the program. Lastly, so why do we care about these RMD rules? What's the problem if you violate them? So the penalties here are actually pretty severe, and there are penalties for both the plan sponsor if you violate these rules. You in a qualified retirement plan, you disqualify the retirement plan. Not a good thing. And there also is an excise tax on the participant, whether it's in a qualified plan or an IRA, who does not get the required minimum distribution, and the excise tax is 50% of the under distribution. And so this is a pretty hefty excise tax. There's some reasonable cause exceptions, but generally these are rules you want to try and comply with, because the penalties for failing to comply are pretty significant. Okay, so what's kind of the motivating principle behind the tax planning in this area? So in many cases, retirement plans are going to be the most or one of the most valuable assets that somebody has. They may have worked in several jobs over their career where they had retirement plan interests. Maybe some of that money or all that money was transferred to rollover IRAs. They come to retirement age. They may have a qualified plan and several IRAs, in which they may have accumulated substantial assets. As I think most people know, assets held in qualified plans are not subject to taxation until distributed. So this is like where it's kind of the big benefit is, because you can hold these assets for many years until you get to retirement age, have tax-free buildup, and that's really kind of, from a tax perspective, kind of the most valuable thing about this. I know we like the deductions, but it's really the tax-free buildup, which is really where the opportunity is to accumulate wealth. So the perspective that I am going to be coming from today, and this is some kind of the tax and financial planning perspective, is that basically the goal is to withdraw as little as possible, as late as possible. And the purpose of this is to maximize tax-free accumulation and build wealth. Now, that may not be your objective, or that may not be your client's objective. In a particular case, you may need the money sooner. So you may have some reason why you want to spend this money during your lifetime, or why you want to take the money out faster than the law requires, and that's fine. Everybody has their personal objectives, but for tax planning purposes and for purposes of this presentation, what I'm really going to be talking about here is what can you do to take as little as possible, as late as possible. And that's kind of the principle that drives the tax planning in this area for most people, not necessarily for everybody, but for most people. And that's the objective that I'm going to be, and the perspective I'm going to be coming from in this presentation. So I'm going to start for a while talking about the pre-2020 law, okay? And you might say, well, why are you wasting my time talking about pre-2020 law when you've just told me that the law has changed? Well, the law has changed, but the pre-2020 law is still very much with us, okay? And if you look at the statute, what Congress did in the Secure Act and in the CARES Act as well, is basically they took the existing statute and they left most of it in place, and they engrafted onto it certain additional rules. So in order to understand the new rules, you kind of got to understand the old rules. And if you didn't, and if you understood the old rules perfectly, great, but a lot of people didn't even understand the old rules that well. There were certain confusions about a lot of the old rules. So I'm going to spend some time talking about it. Also, another reason why the old rules, the pre-2020 law, is still very much with us is because some people are grandfathered. And for them, the pre-2020 law is their law because they were grandfathered and the new rules don't apply to them. So you have to know both the old law and the new law. You can't really get the new law without understanding the old law. So I'm going to spend some time discussing the pre-2020 law and how it still continues to be with us. And basically, the basic rule, which I think most people are familiar with, is that if you're in a qualified plan or an IRA, you've got to start taking your annual RMDs. Again, I'm going to use that term over and over again. That's the abbreviation for required minimum distributions from the IRA or the plan by the quote unquote required beginning date, which under pre-2020 law was the April 1st of the calendar year following the year in which the participant attained age 70 and a half. Now, under the pre-2020 law and even under the new law, there is an extended required beginning date applicable to qualified plans only for people who worked beyond age 70 and a half. So if you are in a qualified plan, not an IRA, but if you are in a qualified plan and you are working past 70 and a half, you don't have to take your money until you actually stop working. This rule does not apply to IRAs, and it also does not apply to 5% owners in qualified plans. So for people who are the owners of their businesses, they're going to have to start taking the money at 70 and a half under the old law, or as we'll see in a few minutes, 72 under the Secure Act. In addition, there's some very funky rules for defined benefit plans where even if you were waiting, even if you were working past your required beginning date and you wanted to wait until you actually retired to take your RMDs, if you were in a defined benefit plan, the defined benefit plan would have to give you an actuarial adjustment upward for the late start. And a lot of big plans didn't want to do that. So a lot of big plans required people to start taking it to 70 and a half, even large defined benefit plans, even if they were still working. So they didn't have to make this actuarial adjustment. So yes, you had this extended required beginning date for people who kept working, but there were a number of circumstances in which it didn't apply. And once you reach your required beginning date, then your RMDs are calculated based on the value of the IRA and the IRA owner's life expectancy. So you have to know, one of the things you have to know is what's the IRA owner's life expectancy. And there are two main tables for this purpose. There is something called the Uniform Life Table, which some of my colleagues refer to as the good table, because that's the table that you use for computing required minimum distributions while you're still alive. In other words, while the IRA holder is alive and taking required minimum distributions. And why this is a good table is that this Uniform Life Table is basically determined based on a combined life expectancy of an IRA owner and a hypothetical spouse who is 10 years younger than the IRA owner. And you get to use this table whether you're married or not, if you're single, whether you're married, if your spouse is only 3 years younger, you still get to use this table. So it's very favorable. If by some chance you have a spouse who's more than 10 years younger, then there's a special table for figuring joint life expectancies in that case. But in most cases, for lifetime distributions, you're going to be using this Uniform Life Table. After death, RMDs are not based on this table. They're based on the beneficiary's life expectancy using a single life table, which is less favorable because it's a single life table. So you have to know which table you're on, and you need to make sure that you're using the right table. Now, as I indicated earlier, final regulations were issued in November 2020, which changed these tables effective in 2022. So the new tables are now in effect for 2022 RMDs, and these use shorter life expectancy. These use, longer life expectancies. Let's say that again. These use longer life expectancies than the prior tables, resulting in smaller required minimum distributions. So these new tables are good news for participants who want to keep more money in their IRAs and defer more. So the new tables are in effect for 2022 RMDs. And again, the basic rule is to calculate the RMD for a particular year. You divide the balance of the IRA or your plan account on December 31st of the previous year by the factor next to the owner's age on the applicable table. And again, make sure you're using the right table. Now, if you have an IRA, after the owner's death, the IRA becomes what they call an inherited IRA. And the RMD rules depend on whether the beneficiary is the surviving spouse or somebody else. If the beneficiary of the IRA is somebody else, then a very favorable rule is available. And under this very favorable rule, a surviving spouse who is the sole beneficiary can treat an inherited IRA as his or her own rather than an inherited IRA. This means the spouse will be subject to the same rules as the original owner. The spouse doesn't have to start taking the RMDs until he or she turns 70 and a half under the old rules or 72 under the new rules. And RMDs, and this is again very important, will be calculated using the more favorable uniform life table based on the spouse's life expectancy, better than the beneficiary table. So here's an example. Let's say you have a decedent who dies at 73. The decedent's already been taking RMDs. But the decedent is named the surviving spouse as the sole beneficiary, and the surviving spouse is now 67. The surviving spouse can say, you know what? I'm treating this IRA as my own because I'm the sole beneficiary. And since I'm 67, I don't have to take RMDs anymore. I can wait until I'm 72. And then when I'm 72, I get to use the good table because I've treated this IRA as my own. By contrast, if the surviving spouse did not make this election, then the surviving spouse would have to start taking benefits right away as a beneficiary and use the less favorable table. So the ability to make this election to treat the IRA as his or her own as a surviving spouse is a very powerful benefit. And we'll come back to this and we'll see how this can be used in some different contexts. But what happens if you have a non-spouse beneficiary? Then the inherited IRA may not be treated as his or her own by the beneficiary, and the beneficiary must begin taking RMDs regardless of whether the individual has attained age 70 and a half. So if your sole beneficiary is your child who's age 35, then they're going to have to start taking RMDs based on their age, not on attaining age 70 and a half, in the year after the decedent's death. Now, under the old rules, if an individual qualified as a designated beneficiary of an inherited IRA, which basically means that they were either an individual or a trust for an individual, then they could take RMDs under one of two methods. The life expectancy rule, where you basically got to stretch out your distributions over your life expectancy, although on the beneficiary table, or the 5-year rule. So under the pre-2020 law, pretty much most people who were looking to defer distributions used the life expectancy rule. And this was actually a very powerful way to defer distributions way into the future. Now, note that if you were in a qualified plan, you might not have had this option because the law allowed plans to adopt whichever rule they wanted to apply. They were not obligated to use the life expectancy rule or the 5-year rule. So it was always a good idea to check your plan documents to see what rule applied. But under the pre-2020 law, you had this life expectancy rule that allowed beneficiaries to stretch out over their whole life expectancy, regardless of whether they were a spouse or the next generation or whatever. Also, there are special rules in the regulations which are still, and these are, even though these are pre-2020 law, there are special rules where a trust was named as a beneficiary. And basically, for nearly all trusts, what happens is that the regulations provide you look through the trust to see who the beneficiaries are of the trust, and then the beneficiaries of the trust are treated as the beneficiaries of the employee for RMD purposes. And the oldest of the beneficiaries was the governing life for RMD purposes if a trust was named as the beneficiary. So as some of my colleagues know, I'm not a big fan of naming trusts as beneficiaries for IRAs. I'm going to talk about this for a few minutes. I'm going to give you my perspective on this. There are clearly cases where you need to use a trust as a beneficiary. You know, maybe you have a minor, maybe you have somebody has some problems that make them, you know, somebody where they can't be trusted with significant amounts of money. Maybe you're in a second marriage situation where you really want to control what happens to the money after the death of the second spouse. So there are some situations where a trust is usable and desirable for certain specialized purposes, but I would not use trusts reflexively or automatically as a beneficiary, which I think some people do. And the main reason for this is when you're dealing with IRAs, your IRA trustee is some financial institution. It's a Fidelity, a Schwab, Vanguard, Merrill Lynch. And they're in the business of managing money, investing money. They're not necessarily in the business of handling your beneficiary designations. And it's been my experience, other people may have different experience, but we've seen a lot of cases where, you know, to put it bluntly, financial institutions have screwed up complex beneficiary designations. And I mean, I could tell you some stories that, you know, would, you know, surprise you, but yes, and it's often very difficult to deal with them. So if you can, I recommend keeping your beneficiary designation simple. If you have a compelling reason to use a trust. But if you don't have a compelling reason to use a trust, you know, if you have adult children and they're financially responsible, considering naming them the beneficiaries directly rather than using a trust. Your life will be simpler. Also, in the, you know, the world of financial institutions today, beneficiary designations are generally made online. They're usually made when people open up their accounts. Often the IRA agreements, those long pages of fine print that you click through and kind of ignore, sometimes contain provisions that say we only accept beneficiary designations or that are on our forms. So if your attorney, you know, created some great, you know, detailed beneficiary designation, financial institution may not even follow it because it's not on their forms. So my advice is, wherever possible, keep your beneficiary designations as simple as possible. There's also a situation where there is no designated beneficiary. And there the rules are somewhat complicated. There, the applicable distribution is the life expectancy of the employee using the age of the employee as of the employee's birthday and the calendar year of the employee's death. And then in subsequent calendar years, you reduce it by 1 for each subsequent year. So this is a situation in which there is no designated beneficiary, or the beneficiary isn't somebody other than an individual or trust. So if somebody named their estate as the beneficiary or a charity, then this rule can apply. And so this is a circumstance, a special rule that applies where essentially no quote unquote designated beneficiary has been named. And that includes, as I said, both where somebody just forgets to designate a beneficiary, but also something where there is no individual or trust that's been designated. Okay, moving on. So now let's talk to the Secure Act. Now that we know all about everything that happened in the past, let's move on and talk about the Secure Act and see how that applies. So under the Secure Act, the big change that was favorable for IRA owners was that the required beginning date changed. So the date on which IRA owners must start taking their RMDs was raised from 70.5 to 72, and this is effective for individuals who attain age 70.5 on or after 1/1/2020. Now, if you attained age 70.5 in 2019, your required beginning date remained April 1st, 2020, although that was subsequently modified by the CARES Act. We'll come to that in a little while. But except for this change, about the start date, the Secure Act did not change the RMD rules for IRA owners and surviving spouses. Other than this change, the lifetime RMD rules remained the same as we talked about in all those slides you've already been through. Now, again, this is good news because it further reduces lifetime RMDs. By pushing the date ahead, that means there might be 1 or 2 RMDs that you otherwise would have had to take that you didn't have to take before. And you combine this with the new tables, so you basically have 2 favorable changes for lifetime distributions from the perspective of trying to maintain as much money in the plan as long as possible. The change in the tables and the postponement of the required beginning date from 70.5 to 72, or April 1st of the calendar year following the attainment of that age. Now, PostDesk Distributions, this is where the quote unquote bad news from the Secure Act is. And here's the big change, that all distributions from inherited IRAs, and this includes Roth IRAs and qualified plans, for quote unquote designated beneficiaries who are not quote unquote eligible designated beneficiaries, must be distributed by December 31st of the year containing the 10th anniversary of the IRA owner's death. So except for these eligible beneficiaries, the stretch IRA is gone, the life expectancy rule is gone, and everybody's down to 10 years. The only people who have the stretch IRA left are surviving spouses, but that's not really that helpful because, as we know, surviving spouses actually have a better rule that they can claim the IRA as their own. And the other people who are still subject to the stretch out are beneficiaries who are disabled, who have a chronic illness. These terms are defined in the statute. This is something that we'll probably get some more guidance on in the coming regulations. Minor children of the IRA owner, they can use the life expectancy rule until they are no longer minors. When they are no longer minors under applicable state law, then the 10 years start counting. And also individuals who are less than 10 years younger than the participant. So if you, for example, name a sibling as your beneficiary who's less than 10 years younger than the IRA owner, then the life expectancy rule is still available. Except for these 4 groups of individuals, everybody, all other designated beneficiaries are now on this 10-year rule. So that's the big change. Except for these four groups here, everybody's on the 10-year rule. The life expectancy or the stretch out is gone. Now, there's some important effective date rules here that matter. So if you died before December 31st, or if not you died, but if your client died before December 31st, 2019 or 2021 for a governmental plan and certain collectively bargained plans, then you're not subject to the 10-year rule. The life expectancy rule is still there. So people who died a while ago who are taking, and their beneficiaries were taking money out of on the life expectancy rule, they have it. So the decedents who died before December 31st, 2019, they are grandfathered in. The life expectancy rule still exists for their beneficiaries. With one little special transition rule, which I gave you the full text here, so you would have it. But basically what this means is if an IRA owner died before the effective date of the rule, and then the designated beneficiaries, say the surviving spouse dies after that date, and the surviving spouse, for example, treats the IRA as his or her own and designates his or her own beneficiaries of it, then in that circumstance, those subsequent beneficiaries will be subject to the 10-year rule because of the designated beneficiary's death is after the effective date. So a sort of a little funky transition rule for people who died before the effective date, but whose beneficiaries died after the effective date. So just to review here a second, I think it's helpful to think of the world in terms of these 3 groups of beneficiaries. At least it's helpful for me. First, you've got the designated beneficiaries who are eligible designated beneficiaries. The surviving spouses, disabled or chronic illness, minor children, and the less than 10 years younger. They still have the stretch out. That's kind of group number one. They're the preferred. They get the best deal. Then you have designated beneficiaries. Those are individuals or beneficiaries of trusts who are not in those four categories. And that includes children who have attained the age of majority. And by the way, grandchildren and other descendants of any age. So that life expectancy rule for children only applies to children. It does not apply to grandchildren. Grandchildren, they're subject to the 10-year rule, basically from the date of birth. And then there's also this third category, which also have in mind, that's the no designated beneficiary. That's, you left the form blank, or you designated your estate, or you designated only a charity. In that case, neither of these rules apply. You're subject to that rule that we talked about earlier. If you died after your required beginning date, that you determine the age at death, that determines you use the life expectancy under the table for that year, and then you subtract 1 year thereafter. That rule actually, in some cases, may be more favorable than the 10-year rule for people who died at very young, at just after their required beginning date. But I'm not suggesting that not the designated beneficiary, because that creates other problems. But basically, those are that's the world. You've got the designated beneficiaries are in those four categories. You've got all the other designated beneficiaries, and then you have the situation where there are no designated beneficiaries. So I think that's, to me, kind of a helpful way to think about, the different rules and how they apply. Now, the change in these rules created a problem for what are sometimes referred to as conduit trusts. And so prior to the Secure Act, it was, I think, a best practice to provide that if a trust received an RMD, there was immediate distribution of the RMD from the trust to the trust beneficiaries. And the reason why this was a practice under pre-2020 law was that there was an example in the regulations that said that if you accumulate the RMDs in the trust, then you have to look at both the income beneficiaries and the remainder beneficiaries to determine the measuring life. And there was a concern, okay, the problem didn't arise that often, but there was a concern that if you had a remainder beneficiary inadvertently who was older than the income beneficiaries, could happen, that would somehow adversely affect your RMD planning. So to avoid that risk, it was often provided, and I think this was sort of, I would call this a best practice prior to 2020, certainly very common provision, that when the RMD came into the trust, it was immediately distributed out to the income beneficiary. And that way you were assured, because of these examples under the regulations, that it was that income beneficiary's life expectancy that was going to govern the RMD, that you didn't have to worry about this inadvertent remainder beneficiary. And also under the life expectancy rule, annual distributions were generally small, and so people didn't really worry about this. Maybe they were distributing at 4 or 5% a year. It wasn't that big a deal. So they generally were okay with these provisions, and it was fine for the trustee to distribute out the RMD. Now you have this 10-year rule, okay? And all the money has to come out over 10 years in most cases. So now, how do these conduit trusts look? Because you had this provision that said the RMDs, when they come in, have to be distributed out right away. So now what you're talking about is significantly larger distributions under the 10-year rule than you had under the life expectancy rule. So this is an issue where people who have this provision in their trusts really need to go back and look at it and talk to their clients as to whether they still want this provision. And in many cases, they might be fine with it. They would say, sure, distribute the money to my kids. I don't have a problem. But in some cases, they may have an issue with it, and they may not want the money coming out with that fast. And they may want to say, well, under this 10-year rule, I'm not really, the money's got to come out at 10 years anyway. I'm not really concerned about these inadvertent remainder beneficiaries screwing up the RMD distributions because the life expectancy doesn't matter anymore. It's all got to come out after over 10 years anyway. So I'm fine with accumulating it, and I don't want my kids maybe to get the money that fast. So this is an issue where I think, and there were a lot of articles about this. I think some of them are maybe excessively scary, shall we say, making it sound like, the world was coming to an end because of the Secure Act change. But I think this is something where people who have trusts as beneficiaries of their IRAs or qualified plans should go back and look at this. Do you have these conduit provisions that require immediate distribution of the RMDs to come out to the income beneficiary? And are you still okay with it? And maybe you are, and maybe you aren't. But this is a point that I think people kind of need to look at where they have trusts as beneficiaries. Okay, so what are some tax plans? What do you look at this 10-year rule and you hate it, and and you say, well, what can I do? I don't want, and also, by the way, just to make a point, under this 10-year rule, the money does not have to be distributed each year. You could theoretically wait until the end of the 10 years to distribute all the money. It's not like under the life expectancy rule where money had to come out every year. So this creates some interesting options for Roth IRAs where distributions from the IRA are not, if you did everything correctly, are not taxable because you paid some tax up front. Now, in a traditional IRA, you might say, well, even if I have this 10-year rule, I want to spread the distributions out because, I'm going to have to pay income tax on the distributions. And if I put it all at the end, it's going to put, the beneficiaries in a higher bracket, the tax rate will be higher. But in Roth RMDs, you don't have to worry about that. So I think these Secure Act rules kind of make it worthwhile to take another look at Roth IRA conversions. So under a Roth IRA, there's some important rules to recognize. First of all, there are no lifetime RMDs from Roth IRAs, okay? They're only post-death RMDs. Roth IRAs are excluded from the lifetime RMD rules. So if you have a surviving spouse as the sole beneficiary of your IRA, and the surviving spouse makes the election that I'm talking about to treat the IRA as his or her own, then there's no RMDs during the lifetime of the participant. There's no RMDs during the lifetime of the surviving spouse. And then all distributions could be postponed basically until 10 years after the death of the survivor. So for example, let's say you're looking at, you could even be looking at a couple in their, 60s or 70s even, they may still have a joint life expectancy between them of 20 years. And you add on to that another 10 years under the Secure Act rule, you could, in a Roth IRA, if you make the conversion, you could go like 30 years with no RMDs. That's a lot of tax-free buildup. And basically, you would wait until like the end of the 10-year period to take the money out because it's a Roth IRA. The money coming out is not taxable, so there's no incentive to take the money out sooner. Now, of course, to do this, you have to make the Roth IRA conversion. And the Roth IRA conversion is going to, is going to be expensive. The Roth IRA conversion is going to require payment of income tax on the current account balance. But all distributions are going to be tax-free if the rules are satisfied. And also, any tax-free buildup you make after the Roth IRA conversion is going to escape tax entirely. So these Roth IRA conversions are worth taking a look at again. Now, market downturns also may be an opportune time for a Roth IRA conversion. It's hard to time the market, but we've had some volatility. If you have a significant drop in the market and people's IRA values go down, that's clearly an opportune time for a Roth IRA conversion. So I think this is worthwhile thinking about. It's especially attractive for people who have assets outside of the IRA with which they can pay the tax. If you have to dig into the IRA to pay the tax, not so good. Although there are studies that even show even doing that, if you have a long enough time horizon, pays off. But in general, this is more a recommended strategy for people who have the assets outside of the IRA with which they can pay the tax on the conversion. Some other advantages of it, it also removes from the taxable estate, excuse me, the assets used to pay the taxes. It's kind of like a prepayment of the income tax. And again, for individuals who have assets outside of the IRA with which they can pay the tax on the conversion, I think this remains a very attractive option. Hang on here, I'm starting to lose my voice. Now, in the time remaining, I see we have a few questions. I'm going to try and stop talking about 120, but I want to say a little bit about the CARES Act. Some of this is review, some of this is kind of, some of this is not completely relevant anymore, but there's one issue that remains relevant. That's why I still talk about the CARES Act. So basically, under the CARES Act, there was a waiver of all RMDs for 2020 from defined contribution plans and IRAs. The CARES Act was the pandemic relief legislation that was passed in March of 2020. And they basically said, we're going to give you a complete pass on 2020 IRAs, 2020 RMDs from defined contribution plans and IRAs. Didn't apply to defined benefit plans, but it did apply to defined contribution plans and IRAs. And this even included people who had a required beginning date in 2020 if they had attained age 70 and a half in 2019. So great, nice opportunity. But here was the problem. The CARES Act didn't pass until March, and some people didn't find out about it right away. And there were people who were kind of eager beavers who take their RMDs in January. And so there was an issue with, well, what happened if you took your RMD in January, February, March before this statute was enacted or before you knew about it? Were you out of luck? Were you stuck with the RMD, or could you somehow put it back? Now, by the way, if you took your RMD before January 1st, if you were due to take your first RMD on April 1st, 2020, and you decided, oh, I'm not even going to wait till then, I'm going to take it in December of 2019, the waiver didn't apply to you. But if you took an RMD in after January 1 of 2020, then you weren't obligated to do it, and the IRS allowed people to pay the money back. And what the IRS came out with a notice in 2020, IRS notice 2020-51, that basically said, if you were in that situation where you took your money out before you knew about the CARES Act waiver, or before the statute was enacted in 2020, you had until August 31, 2020 to pay it off. And if you didn't do that, you still had the 60-day rollover deadline to put the money back into the IRA, to do a tax-free rollover to put the money back. Hopefully most people did that. But if you have a situation where somebody took their money out in 2020, didn't realize they didn't have to, and still haven't paid the money back, there actually still is an option for them. And that is, oops, I went too far here. Yeah, no, that's the right slide, excuse me. Also under the CARES Act, there was something called a coronavirus distribution, or a coronavirus related distribution. And basically what the CARES Act also provided for was that you could take up to $100,000 out of your IRA or defined contribution plan if you had some specified harm as a result of the pandemic. Either you had a health issue or a financial harm, and there were a bunch of them, and they were specified in the statute. And if you did that, you could take the money out, and also you had 3 years in which you could put the money back on it and have the distribution then treated as a tax-free. So if you took the money out in 2020, you basically had until sometime in 2023 to put the money back. And if you did, then you could get a refund of the tax you paid in 2020 on the distribution. So if you have individuals who are in this situation and they suffered some harm as a result of the pandemic, either a health harm or a business harm, then this option may apply to you. You may be able to pay the RMD back, not under the RMD rules, but under the rules for the coronavirus-related distributions, and kind of get your money back if you took an RMD in 2020 and you paid the tax on it at that time. Okay, we're not quite at 120. I would say we're at 115, 117. But since my voice is starting to go and I've come to the end of my slides, I talk very fast and there's some questions. Let's look at the questions. So I'm going to take a look at the questions here.
I had one question. I mean, I think I know the answer, but I thought I would ask it anyway. And then if anyone else has questions, please put it in the chat or the Q&A, because we can't hear you through this webinar format.
Yes. Are the questions now
So
showing up on the screen because I opened up the box?
Yeah, my question is, if you're subjected to, if you're come within the 10-year rule, do you have to take any RMD before the end of the 10-year period?
No, you can wait. You can wait until the last day of the 10 years to take the RMD. But you're just
that's a pretty good deal,
but you're going to be bunching a lot of money into that year, and that may have an effect on your bracket.
Right. So it's probably good to do some planning that way because of the tax impact of taking the whole thing in year 10.
Right, and that's why. But that's a different consideration in a Roth IRA, because in a Roth IRA the distributions aren't taxable. Therefore, in a Roth IRA you'd always want to wait till the end.
Want to take it at the end? Okay. All right. I don't see any other Q&As or anything else in the chat. I don't see anything else, Bob.
I see 4 questions here.
Really? Because I'm looking in the Q&A and I don't. All right, well, go ahead then.
I see 4 questions and it's not even passed over yet. So here are the questions that I see. What options does a surviving spouse have where they were named a beneficiary of a participant who was past the age of RMDs? Can they elect the pad under the 10-year rule during any point at which they can do a rollover? Can they elect the pad under 5-year rule? Or are they limited to either a lifetime pad? Okay, so this harkens back to my favorite rule that I've talked about like 3 or 4 times already, that if you have somebody who is named a surviving spouse who's the sole beneficiary, then the best thing that individual can do is that they can elect to treat the IRA as their own, and even if the surviving spouse is under age 72, they can wait with taking the RMDs, or if they're already over 72, they would have to continue taking RMDs, but again, they're on the more favorable table, the table that assumes everybody has a spouse who's 10 years younger, the joint life expectancy table. So in the situation you're describing, the best situation is to treat the IRA as their own, and then use the the more favorable table to take distributions, and then they're not subject to the 10-year rule or the 5-year rule either. If they live to be 100, they'll keep taking RMDs during their entire lifetime.
There's a follow-up on that. What if the spouse in that example is 92?
I mean, you'd have to run the numbers, but I suspect that you'd look at the tables. For somebody who's at a very old age, what would be under the uniform life table? What would the distributions be? I mean, maybe it's possible that the 10-year is waiting until the end of the 10 years is better. You just really have to look at the tables and run the numbers.
Okay, you can read them or I can read them, however you want to do this.
I've talked enough. I'll let you read them.
Okay. There's another question on inherited IRAs. For those taking RMDs from an inherited IRA from 2017, will the new regs with longer life tables apply to those IRAs?
Yes. Right. So the new tables are applicable to everybody. Hello, Shannon. Nice to see you, at least on Zoom. So yes, the new tables are applicable to everybody for 2022 RMDs. The catch with the new tables, and since we have a minute here, I'll talk about it, is that if you are taking your first RMD on April 1st, 2022, because you attained age 72 in 2021, which I'm getting this, then that distribution is actually a 2021 RMD, and it's on the old table, but the distribution that you take that would be due on December 31st, 2022, that will be under the new table. But yeah, but everybody's on it. People who's, in your case, somebody who started taking their whether it's inherited IRA or lifetime IRA distributions, you start taking your RMDs years ago, you get to use the new table starting with your 2022 RMDs.
All right, here's a quick question. Where does the younger spouse take the election? On the tax return, or is there a special form?
No, really what you do is it's really with the IRA trustee, that the IRA trustee basically has to retitle the IRA as opposed to being in the name of husband. It's retitled, and I'm using husband, and the husband is the decedent and the wife is as the surviving spouse. It doesn't have to be that way. I'm just using that as an example, of course. Originally it was husband IRA, and then it becomes husband inherited IRA, then it has to be basically designated on the books and records of the trustees now as wife IRA, and that's how you do it.
Okay. All right. Okay, Susan Abraham asks this question. If an unmarried participant names his living trust as a beneficiary, and on his death, the trust breaks into 2 lifetime subtrusts for 2 kids, and the living trust does not have conduit provisions, does the trustee get 10 years to take out the plan and pay all income tax? If so, does the plan remain in the participant's name until that time?
Right. So if we're talking about an IRA here, and you said is this question in the chat? I'm not seeing it.
It's in the Q&A.
It's always helpful to actually see the question.
You see the Q&A box there? I can cut and paste it into the chat if it's easier for you.
Oh, hang on.
Put it in there.
Oh, here it is.
Oh, Susan,
okay, I got it. Okay, if an unmarried participant names his living trust as beneficiary, and on his death, the trust breaks into 2 lifetime subtrusts, got that for 2 kids. Yeah, yes. If you don't have conduit provisions, then the trustee can let the money sit there for 10 years. Now, of course, yes, yes, exactly. You could wait out the whole 10 years in that situation, because there, in effect, what you're doing is, what you're going to say is, you're going to wait for the trust to take the money from the IRA until the end of the 10-year period, which is fine, and then you just pay then you can accumulate it in the trust or not.
Okay. All right.
Let me just pay 10 years to pay out. Let me just see what it says at the end. If so, does the plan remain in the participant's name until that time? So basically, with an IRA, they're going to treat it as inherited IRA, for the benefit of the trust. It does remain as if it's an IRA, it does in effect remain in the participant's name, but as an inherited IRA, it'll be redesignated as that. And yeah, they can wait until 10 years. They can wait until the end of the 10 years to take the money out.
All right, thanks. Okay, Murray Kamyansky asks, want to confirm if I continue to work as a sole practitioner attorney until I am 80, then I do not have to take any RMD from my defined benefit plan. Is that correct?
No, because if you're a 5% owner of the, it depends on what your position is, I suppose, with the law practice. If it's your solo practice and you're a 5% owner of the practice, then you've got to start taking the money out at 72 under the new rules. If you are not a 5% owner, if you were, for example, an employee, then you could wait. But if you're a 5% owner, you got to start taking the money out right away at 72.
All right. And finally, Jennifer McNeil Lozano asks if the IRA is paid to the trust, but the trustee and all beneficiaries agreed to assign their interest to be paid directly, does each beneficiary have 10 years for distribution? I think that's two
right.
different.
So the 10 years is right. So under the 10-year rule, so under the old rules, we used to worry about life expectancies. And if there was only one trust, then the oldest beneficiary governed. But now under the 10-year rule, the 10-year is measured from the end of the calendar year in which the decedent passed away. So yeah, so the money can all come out up to the last day of the 10th year after the decedent has passed away.
Right. Yeah. Well, because that's when it goes to the trust, and then from the trust.
What happens in the trust is then a different situation. I mean, remember, the 10-year rule applies to payments from the plan. So if the trustee is beneficiary, the 10-year deadline applies to the payments from the plan to the trust. What the trust does with it then depends on the trust provisions, whether it accumulates in the trust or whether it gets paid out right away.
Exactly. Okay, I think that 1 second, I see one more comment in the chat. Hold on. Is that a new comment or is it something we already did? Oh, where is that chat box? No. Okay. Well, Bob, we are just about almost at 1:30. So thank you so much. This was really informative. We all really enjoyed it. I really appreciate your time on this. I am sure if people have questions, they can reach out to you. Yes,
absolutely.
Your contact information is available. It's in the materials. So thank you for that. If you are interested, and this is to the participants, if you're interested in becoming more active in the tax section, we will be having our meeting next Thursday morning. I encourage you to attend. If you want to present or if you have ideas for presentations, please join us. And thank you, everybody. And next month, there's going to be the entertainment section is putting on a program called NFT Week, and there will be a tax panel during that week. So more details to follow. So look out for that. All right, everybody. Thank you so much and have a wonderful rest of your day. Bye-bye.
Take care. Bye-bye.